Hi, this is Carl with another SOP video for managed service providers. Today I want to talk to you about service agreements, and in particular, 7 reasons why you need to have or perhaps update your managed service agreement. First, let's start at the beginning. Your service agreement is not about your service. Your service agreement is fundamentally an agreement about your relationship with your client. It literally lays the groundwork of how we're going to proceed with this relationship. So it sets the tone. It's part of your branding. It's part of your professionalism. It's part of how you define the way that you're going to proceed, what you can expect and what the client can expect. So that's probably the most important thing. All the details, they fine-tune some stuff, but fundamentally the document as a whole is about the relationship. Second, you need a contract because you need to keep your taxes straight. More and more, not just in the United States, but across many countries, many jurisdictions, there's a distinction between people who are employees who get certain benefits and people who are contractors who do not get those benefits. They have to separate their taxes. Your contract is one of the key elements in defining that relationship that says, we are not an employee, you are not our employer, you don't have to collect our employment-related taxes and unemployment and so forth. So it's really important that you make this distinction so that down the road, if there's any questions about stuff, it's very easy. Now, in every jurisdiction, literally pretty much every place I've ever looked, many countries, I have found a site that says, here's how we define the difference between employees and contractors. And guess what? A key element in every jurisdiction is, do you have a signed contract that specifically says we are a contractor, not an employee? Third, and somewhat related, is the strictly legal relationship between you and your client. Your contract defines the legal relationship. It says we are bound by this jurisdiction, whether that's your state, your province, whatever. And those are the laws that are going to guide how we move forward. I know that sounds picky, but it's one of those things where you just have to realize nobody cares what's in your contract until something goes wrong. So when something goes wrong, what are you going to do about it? Are you going to have an arbiter? Are you going to go to court? Is it going to only involve issues that are above a certain amount? What's the first thing you do? What's the next thing you do? So that legal relationship needs to be in there. It's not huge, it's not complicated, but you have to have it. And here is actually the crux of what happens if you don't have a contract with a client. Then whatever jurisdiction they're in, they and the state or province that you're in will decide what the law is. They will decide what governs your agreement. And it may be something different than what you intended. So when people say, oh, I just go with a handshake, I trust my clients and they trust me, and if it's good enough for them, it's good enough for me, and all that. That was a really great attitude in 1800. But since then, we have lots and lots of laws that regulate how businesses work together, how employees and employers treat each other, how taxes flow. There's literally hundreds of thousands of reasons why you need to define your relationship, and that's a key piece of it. So if you don't have a contract, then the laws of your state, your province, your nation will take precedence over your intentions, and the only way around that is a signed contract. Number 4, and this is a biggie when it comes to any service business, but in particular a managed service business. You need to draw nice dark lines around what's included and what's not, what's billable and what's not. You don't have to define every specific service. In fact, the specific services should be bolted to the end of the contract. They should be an amendment. They should not be part of the actual contract itself. So put the statement of work at the end, but just note the guidelines about billability needs to be in the contract. Again, this goes back to thing number one. You are defining your relationship with the client. So they need to know these sorts of things. For example, maintenance is included in a managed service deal. Adds, moves, changes are not included in a managed service deal, right? Or if it's a flat fee contract or something like that, what's included and what's not. There is no such thing as all you can eat. It's funny, I actually went to an all you can eat restaurant the other day and took a picture of their rules, because there have to be rules, because there is literally no such thing as all you can eat. And everybody knows that, but everybody uses the term, so stop it. Since we know that there's no such thing as all you can eat, don't let the client think there is. If you use the term all you can eat, they're going to get confused and think you actually mean all you can eat. Those words actually mean something to the client, and if they hold you to that, there better be something in writing that says, here are the actual rules for the so-called all you can eat, which is not all you can eat because there's no such thing as all you can eat. Here's what you can eat. Here is the actual menu, and here's where we draw the line between what's billable and what's not. Number 5, ransomware. Now, for the most part, you may not actually mention the term ransomware, but you do have to define in your contract what will happen when there is a catastrophic event, whether that means a failure of a backup, a failure of a cloud system, a failure of a server, right? What happens, who's responsible, what's covered, what's not. You need to put some guidelines in there. Again, the specifics are going to be in a statement of work, but the guidelines about how you handle these things are very important. More and more, we have clients who have lots of problems, and it's their own fault because they responded to phishing, but you play a role because you should be educating them. But they don't pay attention to the education because it's boring and it's not relevant until the day after they get taken for a bunch of money. So it's a complex relationship, which is why there needs to be some statement about how you manage things when things go wrong. Again, nobody cares about what's in your contract until the day after something goes bad. Number 6. And this one has become quite an issue in the last few years. Insurance and liability. You can no longer be in this industry without insurance, without liability. And I have seen multiple instances where people have said to me, I tried to get a quote for insurance, but as soon as I checked the box, it says, I perform backups. It kicked me out and said, sorry, you're not eligible to get insurance. You need insurance, your clients need insurance, and you have to draw some lines about what happens when something bad happens. We all say the words, it's not a matter of if, it's a matter of when, but what that really means is, what will you do when something happens? When there's a catastrophic event, when they get ransomware, when they get something, when they're attacked, when the backup fails, who is responsible for paying for that? How do you proceed? And most importantly, you can say, well, my clients would never sue me. Well, it doesn't matter, because most importantly, their insurance company will sue your insurance company. So you have to have laid out that they have to have liability and it's got to cover certain things. This includes a clause about the tools you use. If you buy an RMM tool and it gets compromised and all of your clients suddenly have ransomware, who is responsible for that? You need not to be responsible for that. You need to have something in your contract that very specifically says, we are not going to end up paying for something like that because we don't build the tool, we don't manage the tool, we don't update the tool. We have no control over that. And so we cannot be held liable for something that goes wrong with our tools. This is a pretty common thing in most businesses. And so you just have to manage it. And at the end of the day, when an attorney looks at a contract, what they're looking at is how are we moving liability from point A to point B. You need to make sure that your liability is limited by your contract. Yes, you have insurance, but you know how insurance works. The minute you have one little incident, your rates double and then you get turned down and it becomes difficult and expensive to continue to have insurance. Insurance will drive people out of this industry. It already has, but we're going to see a lot more of that. So dealing with liability and dealing with insurance absolutely have to be a key piece of your contract. And in fact, I recommend that you have multiple contracts. If you've got a hardware piece, whether it's hardware as a service or whatever, if you're supplying hardware under a service agreement, that needs to be separate from the service part of managed services, which is essentially labor related. Okay, so you have to spend some time drawing some little diagrams about what's included in here and what's included there and how do they overlap and what happens if something goes wrong. I know this is not the fun part of why you got into this business, but it's the important part of how you're going to survive in an era where there are lots of bad guys and they are after you and they're after your clients and they're getting smarter every day. Finally, number 7, and this is something that has kind of emerged in the last 5 to 10 years. What do you do with clients who refuse to take your advice? Your contract needs to limit your liability in this case. If a client says, no, nobody cares about us, we're small, HIPAA doesn't apply to us, FINRA doesn't apply to us, all of these rules and regulations don't apply to us, the government regulations on security and privacy, they don't apply to us, or I just don't care. I've been doing this for 30 years and I've never had any problems, so you can't make me change my ways. First of all, I personally, after 30 years of experience, will tell you I would fire that client. Period. End of story. There's no point in having a client who only increases your liability and does not actually give you a good response. If they don't participate in their own well-being, there's a limit to how much you can do. But let's assume you are willing to keep those clients, or you got to figure out what to do before you fire them. There needs to be something that says, hey, if we gave you advice in writing and you turned it down, then we are not liable for the results of those actions. You know, one of the clauses I've always had in my service agreements, and this is in my book on service agreements that you should buy and download today, is that we specifically say that all work has to be done by us. So if the client installs a piece of software and we have to fix it, that's billable. Right? That goes back to the add, move, change piece. If they install a virus and we have to fix it, that's completely billable. It's on them. So you have to be very careful about this, because even though they own the equipment and they paid for the software and so forth, they are hiring you to take care of their systems. And so you are taking on a certain level of liability simply because you have accepted the job of managing their network. And good for you, but you need to be compensated for that, and you need to draw those nice lines about where your liability stops and theirs starts. When you are giving good advice and they are not taking it, you need to be limited in your liability. You know, there's a lot of discussion about legislation in this industry, and it's beginning to happen. The first state in the US that put together something that specifically calls out managed service providers is the state of Louisiana. And the entire reason that that came into being is that the Secretary of State looked around and saw that MSPs were being paid to secure state systems, but they weren't securing them, and then they got ransomware, and then there was a problem. Well, I will bet you a large lunch at a drive-through window that almost every one of those contracts didn't specifically say, we're going to do backup or we're going to have a backup and disaster recovery system. Instead, they were basic maintenance programs. Backup was not part of it. It wasn't what the state was paying for. And so when they got ransomware, it was their problem. They're the ones who should be liable for it, not the managed service provider. Now, the way that you make sure that you deal with this going forward, offer appropriate services. And then if you get turned down, it's all good. You can demonstrate because you have a contract that says we're not liable when you don't take our excellent advice. A few things to think about. Go forth, create a contract. If you've got a contract, I highly recommend that you have it updated. If you need a referral for that, I now have a great referral, so send me a note, carlp@smallbizthoughts.com. I will be happy to point you to someone who can help you out at a reasonable price. For Small Biz Thoughts, this is Carl Polachuk wishing you the best of luck in your managed service business.